Hello, hello. Share screen. Oh shit! Someone just popped in already. God damn! Beck and Hollow's on the ball. What? What in the butt? Share. All right. Well, Beck and Hollow, you get to witness me putter and fuck around while I try to get this stream going. Because as Dan Marblemouth Dan likes to say, I should do my research ahead of time. But fuck that. But fuck that. Curated docs. There was one from Chili. There's Chili's demur. That's what we're looking for. All right. Hello, little of this and little of that. And hello, Neil McDonald. If you are related to Norm McDonald, at here, I am live. They asked me to do that, and so I have done it. Okay, so what do we got going on here? All right, this is a couple of motions in Wallace's case. Now, a motion for a district judge to reconsider. District judges are going to reconsider these things, and they're going to look for clear error. And clear error means like it's obvious error. It's not like it's not something subtle. It's not a picayunish point. It's not whether or not the judge believes your affidavit or the other side's affidavit. It's whether or not there's clear error. Like if all the evidence points against you, then and the judge still rules in your favor, that might be clear error. So he asks the court to reconsider his motions, to stay this action while I find counsel, and to refer me to the local pro bono panel that this court filed on August 15th, 2023, pursuant to local rule IB 3. There is no, just so you're aware, there is no local rule IB 3-228. But there is a local rule. We're going to show this here instead. And we're going to zoom it in. Control F. IB-3. This is Nevada. And it's IB space 3. Is there IB? Thunder and Tar Nation. This doesn't look right. This doesn't look right. This doesn't look right. Am I in the right spot? This is Northern California. Who's the dumbass who went to... Oh, I always go to Northern California. Google remembers me. Let's see. District Court of Nevada. I will try to be less dumb. I don't make any promises, though. All right. So we are going to do IB3. Boom. And we're going to go IB3-2. Just see there is no 3-222. But anyway, all right. So review of matters that may not be finally determined by a United States magistrate judge in civil and criminal cases, administrative proceedings, probation, revocation proceedings, etc., under 28 USC 636B. So let's go to 636B. All right. I know this is complicated. Follow along. All right. This is 636. Now there's two. So magistrates can do two things. They have some things that they can do like completely, and they can do some things only in part. So notwithstanding any provisional law to the contrary, a judge may designate a magistrate judge to hear and determine any pretrial matter pending before the court, except for a few things. Except for those. So any pretrial matter, a judge can assign it to a magistrate, and it's a final determination on it. A judge of the court may reconsider any pretrial matter under the subparagraph A, where it has been shown that the magistrate's order is clearly erroneous or contrary to law. But this is what he's talking about. A judge may also designate a magistrate judge to conduct hearings, including evidentiary hearings, and to submit to a judge of the court proposed findings of fact and recommendations for the disposition by a judge of the court of any motion accepted in subparagraph A, etc. So the question is his request to be referred to the pro bono panel, was that under subdivision A or subdivision B? The answer to that is subdivision A. So why is he talking about subdivision B? I don't know. But he clearly says 3-2, which I think is what he means there, and USC 636 B1. B1. So it's this part, but then it's this part that applies, B1A. And the local rule is talking about this part, B. So it's talking about this part down here. You see how he fucked this up? I mean, are we seeing how we fucked it up? I hope we're seeing how we fucked it up, because I'm seeing how we fucked it up. Actually, let's go back to this. So there is 3-1, review and appeal. United States magistrate judge, review of matters that may be finally determined by a magistrate judge in civil cases. 28 USC 636 B1A. A district court may reconsider any pretrial matter referred to a magistrate judge in a civil case under LRIB 1-3. LRIB 1-3 is a magistrate judge may hear and finally determine any pretrial matter not specifically enumerated as being exempted in 636 B1A. All right. When it has been shown the magistrate judge's order is clearly erroneous or contrary to law. Again, we're in that clear error. You need to show clear error. Any party wishing to object to the magistrate's order on a pretrial matter must file and serve specific written objections. Specific written objections. Deadline's 14 days. So he's within the deadline. But anyway, he's mixing up local rule IB 3-2 and the wrong part of it should be 3-1 is really what he did wrong there. But he objects and requests a de novo review of the record. He would get the de novo review of the record if it was this one. You file the proposed recommendations and orders, and then a judge shall make a de novo. So he's in the wrong section. Because he's clearly retarded. Clearly. Motion is made based on the included memorandum of points and authorities, the included request for judicial notice, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. All right, let's get into it. Let's he's going to wow us with his legal shenanigans. Okay, on May 24th, I filed this. On defendant LVMPD filed a frivolous motion. Yeah, frivolous. Again, in that motion, he alleges the case is too complex for me to handle on my own. Citation fucking needed. There are so many mosquitoes flying around. I have doused myself liberally with the advanced version of Deep Woods Off. This is the insect repellent 5, long-lasting protection. It's 25% DEET. 25% DEET. And they're still buzzing around. Like I owe them money or something. Get off my lawn. Okay, so he says that they allege the case is too complex for him to handle on his own, but yet they did not say that. Requiring the assistance of well-known constitutional law scholar to write and file my pleadings on the matter. They did say that he did prepare your pleadings and file them, but they never said that it was too complex for you to handle. You wish they did, but they did not. Oh shit, ankles. Oh shit, ankles. My ankles are especially delicious. Just in case you were hungry, my ankles are delicious. And yes, I did spray the junk. Hey, you can use that DEET to fix your cloudy headlights. Well, can I though? Can I? All right. And emailed me to say they would not request it. Great. All right, so here we go. On August 16th, 2023, this court's magistrate judge entered an order denying the motion to say this action to find counsel and the motion to be referred to the local pro bono counsel. This court applied the wrong law and the wrong facts to its decision, and I object under local rule IB 3-2 and 28 USC 636B1 and requested de novo review. Again, he's not going to get a de novo review. This is going to be looked at under the clear error standard. Objection to factual assumptions and findings and ability to pay analysis. The order found that, quote, in this case, plaintiff paid the filing fee, see docket number 4, and has made note showing that he is unable to afford counsel. The order assumes erroneous facts. Does it? Well, he paid the filing fee. The plaintiff's filing fee was paid is another way of phrasing that. It doesn't matter that the plaintiff paid it or that the plaintiff's sugar daddy paid it or that his daddy paid it or that his mommy paid it. It was paid. Ergo, quaderat demonstratum. That's the important thing. And has made no showing that he's unable to afford counsel. Again, the burden is on him. The order assumes erroneous, quote, facts, end quote, and ignores facts presented in this action in reaching an incorrect conclusion. The receipt of docket number 4 does not say who paid the filing fee. The order assumes absent evidence that I paid it, contrary to other evidence in the record. You had the funds available to you. Does that make sense? The LVMPD in their motion admits that Jose Decastro raised the funds to pay the filing fee. Did they? Well, let's look at that. That's the motion. Which motion? That's a motion. Which motion? Let's look. Let's see if we can't suss it out. Which motion do you think is going to have it? I think it's going to be I think it's going to be the one where they ask the court to have here we go. I think it's going to be this one. All right. And it was at 6, what was it? 6:13 to 15. Now, they're going to admit here, let's just get it right. They're going to admit that Jose Decastro raised the funds to pay the filing fee. Admit he raised the funds to pay the filing fee. This is 6:13 to 15. Decastro claims to have helped Wallace raise the funds to file his lawsuit because during the video he gave, quote, a quote, big thank you to everyone who helped crowdfund the cost of Mr. Wallace's lawsuit. Now, if you remember when we were talking about hearsay, they weren't presenting this for the truth of the matter asserted. They were presenting this because the matter was asserted. They don't know and don't care if Decastro raised the money. They don't know or care that. So, and it doesn't even matter. It's still a red herring because at the end of the day, the funds were available to Wallace, and Wallace hasn't shown that the funds are no longer available to him. This shows, additionally, this is shown in the video that includes by reference at 6:23. That's the link to the Chili video. I doubt seriously it shows it. I'm sure it's going to have Chili claiming to have done it. And let's not forget that Chile claimed to have studied the law for 20 years. So I wouldn't really put a lot of stock in what Chile claims. This shows that I did not pay the filing fee. Does it? Does it show that? Well, the filing fee was paid for you. So you had the funds available to have the filing fee paid. It doesn't matter if the money comes out of your wallet or someone else's. It is money available to you. And in part, am unable to afford counsel. You haven't laid out a single fucking fact to show that you're unable to afford counsel. The fact that I'm requesting pro bono service, which people who can afford attorneys do not do. Yes, they do. Yes, they do all the time. All the time. People who could, if they had to, afford an attorney will take an attorney appointed for them because it's free. And the off chance that the court might require them to pay their pro bono attorney, if it's found at some later date that they could afford to pay their pro bono attorney, doesn't change the fact. People all the time ask for attorneys when they can afford one. So no, it does not show that you're unable to afford counsel. Showing that you're unable to afford counsel shows that you're unable to afford counsel. A Harvard Law Review article, who the fuck cares? Economic pressures on lawyers mean that sometimes, despite their best intentions, pro bono clients may receive less attention. About 3/5. So why do you want a pro bono client or attorney if you're going to get less attention from him, Wallace? That's a dumb fucking thing to quote. About 3/5 of surveyed public interest law organizations experienced some quality concerns. 14% reported extensive problems, 33% reported moderate problems, and 8% reported limited problems. So pro bono attorneys are shit. So you're asking for a pro bono attorney because you want a shit attorney. I don't know what the fuck you thought that was saying, but it doesn't say what you thought it was saying. You fucking buffoon. And I'm not saying that to Wallace, because Wallace sure as shit didn't write this. Additionally, I expect the pro bono panel itself is better able to determine if I'm eligible. Well, they will definitely double check your eligibility, but it's still a matter of the court's discretion to refer you to them. See also every order for referral to the pro bono panel, which all include the same language. It is furthermore, this case shall be referred to the pro bono program adopted in the second amended General Order 2019-07 for the purpose of screening for financial eligibility, if necessary. Yeah. And there's also other language in there that we'll get to that means that the court has to do its own little bit of pre-screening because the court has to make some determinations in order to just fucking send you to there so you can get the in-depth screening, you fucking buffoon. In this circuit, unopposed motions for appointment of counsel are granted with no exceptional circumstances required beyond a merit analysis and the plaintiff having had exercised a previous search for counsel. Well, I mean, in this circuit, maybe, but in this particular district, don't you think it should be this particular district we're talking about? Because this second amended General Order 2019-07 refers to how it works in this specific district. Other courts in this circuit don't make the general orders for this fucking district, nor do they interpret the second amended General Order 2019-07 for this fucking district. So why are we talking about other courts in this circuit? There also is no financial need requirement. Well, that's a doozy. Well, let me rephrase that. That might be a doozy, and it might not be, but we'll get there. However, pro se litigants are expected to pay to the extent they can. Now, we're citing a case out of the Western District of Washington. That's really fucking weird. The Western District of Washington? Why are we citing a case out of the Western District of Washington when the fucking general order that we're dealing with is out of the District Court of Nevada? But we'll get there. We will fucking get there because we have a court listener, and the specific one is July 31st, 2019. And look at this, July 31st, 2019. It's fucking amazing that the one I need was bought and paid for and downloaded already. Fucking amazing. It's like I had a calling from God. Order granting plaintiff's motion to appoint counsel. Plaintiff, I'm not even going to try, Nahum, filed an unopposed motion for appointment of counsel because plaintiff's exceptional circumstances recommend appointment of counsel. The court grants plaintiff's motion to appoint counsel. And then we cite an actual citable case, this one right here. And this is out of, where are we at? So this case that they're citing has a mixture of flavors in it. This one, they had to determine he is opposing, this is a guy who's going to get deported, I think to Kenya or something. He had a U.S. wife. She had an issue, couldn't make the hearing. So he got locked up in this Corrections Corporation of America thing. So how do you handle this? Well, there's a Bivens action that you could do against the jailers. There is a federal torts claim act that you could do against the United States government. And there is a regular tort claim that you can do against the Corrections Corporation. So there's 3 different fucking ways that you have to handle getting all the people that he's suing in this. It was a complex case. And it was a proceeding in forma pauperis. What does that mean? It means that he had already shown that he has a lack of funds. So, whoops, shit. Sorry, we're looking at this. So that's Eggman versus Corrections Corp. And now we're going to go back over here. And because of this, the court directs Sharon Haas, coordinator of the pro bono panel, to identify an attorney or law firm from the pro bono panel to represent Mr. Nahum for all further proceedings. See General Order 10-05, Section 4B, Western District of Washington, August 12th, 2010. It's a completely fucking different general order. Isn't that fucking weird? That's crazy to me. And it's also referencing 28 USC 1915. What's 28 USC 1915? Well, that's fucking proceedings in forma pauperis. It means you don't have any goddamn money. E1 is the court may request an attorney to represent any person unable to afford counsel. It all rolls back on itself. How do we not understand this? So to suggest there's no financial need requirement seems pretty stupid because it's all rolling back to a motherfucking financial need requirement. They can't represent a person unable to afford counsel. Unable to afford counsel. That's a financial fucking need. Christ on a cracker. Oh, wait. But wait, there's more. All right, so Western District of Washington General Orders. Oh, you can't see this. Local rules and general orders. And we want archive general orders by year. It was 2010. 2010. Well, it's probably this pro bono plan. What do you think? Think it's a pro bono plan? Ouch, I just lit my nipples on fire. Oof. Do you want to kiss him and make it feel better? Effective August 1, blah, blah, blah. Amended plan, district court, pro se litigants, yada, yada. Here's the plan. It's based on 42 USC section 2000E. That is the EEOC, right? I can't highlight that, but I believe that's a Equal Opportunity Employment Commission. And 28 USC section 1915. That's in forma pauperis. And let's see what kind of things they lay out there. Factors to determine whether to appoint counsel. Now remember, let's go back to the big argument. Are granted with no exceptional circumstances required beyond a merit analysis, right? Merit analysis and the plaintiff having had exercised a previous search for counsel. That's all that they need. That's all that they need, right? All that they need. Oh, but look at all these silly factors that they're supposed to take into account in this general order. The inability of the pro se party to retain counsel by other means. That is I can't afford it, because if you can afford it, you can retain counsel. I should, Jose. You're right. The potential merit of the claims, the nature and complexity, the presence of conflicting testimony. You'll see this all again, because this order looks basically identical to the order in Nevada. So, yeah, looks basically fucking identical. Basically fucking identical. But yeah, it seems like there's more there than just the exceptional circumstances requirement. Seems like there's a few more, just a touch, a skosh more that they have to consider than just the exceptional needs requirement. Fucking weird. When facts alleged are insufficient to grant a motion, local rule IB 1-4 says that a magistrate judge is to conduct any necessary evidentiary or other hearings to determine pretrial matters. Does it say that? Well, I guess we should fucking look at it, shouldn't we? Local rule IB 1-4. So we're going to scroll up here a little bit. 1-4. Findings and recommendations. This is under 636B1B. Remember, 636B1B is the stuff that is not where the magistrate judge does a final determination. 636B1A is where the magistrate judge finally determines any pretrial matter, right? When a district judge refers to a magistrate judge a motion, petition, or application that a magistrate judge may not finally determine under 636B1B, the magistrate judge must review it, conduct any necessary evidentiary or other hearings, and file findings and recommendations for disposition by the district judge. Motions subject to this referral include all of these things, none of which include a petition for a pro bono attorney. So basically, he's fucking wrong to cite this. And it doesn't say that if the magistrate judge, what did he say? The magistrate judge is to conduct any necessary, when facts alleged are insufficient to grant a motion, a magistrate judge is to conduct a necessary evidentiary hearing. It doesn't say that. It doesn't say that. What this local rule is for is when the district judge wants the magistrate to conduct the hearing so that the magistrate judge can make a recommendation. It's not for, if all the pleadings on the motion, if no one is objecting to anything, then I still need to do an evidentiary hearing. No, just no. Here, the magistrate judge instead made assumptions contrary to the record. No, you dumb shit. You did not allege the proper things. You did not allege the proper fucking things and deny the motion. Yes, the magistrate judge did deny the motion. Properly denied it. There was no clear error there. It is also obvious the record was not reviewed. Why does Chile always think that nobody's reviewing the fucking record? He was accusing Wish of this. He was accusing Google of this. He accused everybody of this. Nobody but Chile is reviewing the record. I mean, Chile's straight up lying about the record. He's making up shit that people didn't say in the record, but everybody else is not reviewing it. Generally, pro se plaintiffs are granted the opportunity to offer proof. You dumb shit. You could have attached an affidavit to your fucking motion. You didn't. Here, plaintiff was not offered that opportunity. No, you dumb shit. You could have attached an affidavit to your fucking motion. Courts in this district have found that when there's insufficient evidence to determine if a referral is warranted, they have denied motions for referral without prejudice. I believe this probably was denied without prejudice. They just didn't say it. Here, instead, the magistrate judge assumed facts. No, the magistrate judge found that there was sufficient evidence for the judge to deny the fucking motion. That's what the judge found. He didn't make incorrect determinations of fact. Your fucking failure to properly plead and to properly put forth things into affidavits is your fucking problem, not the judge's. The judge doesn't have to make shit up for you. The judge doesn't have to read between the lines. The judge has to have evidentiary hearings just to see whether or not you fucking qualify for a pro bono counsel, you fucking idiot. Additionally, a magistrate judge seems to lack the jurisdiction to try facts without consent of all parties in an evidentiary hearing. She was not trying facts. You dumb shit. What do we got here? What do we have here? Share this tab instead. We appointed a special master to conduct a contempt trial and must now rule on his however, because the magistrate was statutorily barred from assuming jurisdiction on the criminal portion of the case, we cannot rule on his criminal recommendations. Instead, we must start from scratch and refer to the matter to a new special master. There was no special master referred here. Why are we talking about this case? There was no special master. The magistrate judge was allowed to deal with all the pre-trial, non-dispositive motions and issues. And that's clearly what this was. Can I get pro bono counsel? None of this is dispositive. None of this requires a special master. You fucking clown. Here, the order indicates that an evidentiary hearing without oral arguments was held. Does it? Did it fucking say that? Citation ever so clearly fucking needed. Let's look at the goddamn order. Let's see where it says. It says the motions are properly resolved without a hearing. The motions are properly resolved without a hearing. Properly resolved without a hearing. It does not indicate an evidentiary hearing was held without oral argument. It says, once again, the motions are properly resolved without a hearing. There's no oral argument on it. No oral argument on it. Finally, it seems unlikely that a reasonable person could have reviewed the video of the incident and seen that recording from public could be considered attempted trespass or failed to see that a gun was pointed at plaintiff's head. See, whether or not it's attempted trespass, that is going to be a legal conclusion. The elements are what the prosecution is required to prove in an attempted trespass, not the ultimate conclusion. That, I mean, if all these elements are met, then the jury is supposed to find that it was attempted trespass, but that's an ultimate conclusion, not a fact. Or failed to see that a gun was pointed at plaintiff's head. Well, what does that mean as far as a pro bono attorney? None of this is relevant, which defendants admit is a ground for excessive force claims. ECF number 8 at 1212. Well, let's go back to ECF. What are we doing? 8 at 1212. 8 at 12. The only force referenced by the complaint beyond the lawful search of Wallace's person is an officer drew his gun while approaching Wallace. Court's approach. Here, Wallace alleges an officer approached him with a gun drawn. Wallace does not allege the officer threatened him with a firearm or pointed at his head. Yeah, you didn't allege it. So what the fuck is your argument again? Which defendants admit as grounds for an excessive force claim. Well, you didn't cite exactly where it is, so I'm going to guess it's not actually in there. And they're specifically denying it. So I'm going to go with no. You're fucking wrong and dumb and wrong. The pleadings and the videos clearly articulate a cognizable claim for relief. Why are we talking about this? This is about your pro bono claim, your pro bono request. It seems more likely the order did not account for the differences between providing an opinion on the merits of a case with merit analysis. Well, so the merits, I don't know. I don't think that there is any real chance of recovery for Floyd. He loses on a lot of different levels. And what he has not alleged is an actual monetary loss. And based purely on that, based purely on the fact that he doesn't have any fucking loss, any monetary loss, he has no real chance of recovery. So the Ninth Circuit has indicated an articulation of a cognizable claim for relief may itself be sufficient to satisfy the merit analysis on a motion for appointment of counsel. Id. All right. We'll look at it. Ninth Circuit, he says. This is the Ninth Circuit. Oh, you can't see this. This is his Tilley versus McGinnis. This is the 642 Federal Appendix 719, Ninth Circuit. Not for motherfucking publication. This disposition is not appropriate for publication. It is not precedent. Chile does not fucking know what cases to cite to or how to cite to them. It seemed more likely that the order did not account for the blah, blah, blah. Wrong law applied. The order applied my request for a referral to the local pro bono panel under the exceptional circumstances of federal requests to appoint counsel. The order applied my request for a referral to the local pro bono panel under the exceptional circumstances of federal request to appoint counsel. Let's take a look. Let's take a little looky-loo. A little peeky-poo. So there's one test. And this is under 28 U.S.C. 1915. We'll do so only in exceptional circumstances. The court, right? Right. No success on the merits. Right. No likelihood. See Palmer. As such, the court will appoint counsel. The court may refer them. Right. General order, yada, yada. Such referral is highly discretionary and turns on some of the same considerations addressed above, including the inability to retain counsel by other means. This means the inability to pay for counsel, the potential merits of the claims, and the capability of the movement to present the case. Mm-hmm. Yep. Goddamn mosquitoes. So, so the court applied my request for referral under the exceptional circumstances. Well, the question is, did he request it under 1915 E1? Well, let's take us another little peeky poo. Another little peeky poo. Motion for referral. That's this one. Oop, we're sharing this tab instead. Did he request it under 1915 E1? Oh, look, he requested under 1915 E1. Would you fucking look at that? Would you fucking look at that? So the court applied the law that's relevant to a request for an attorney under 1915 E1. But wait, let's also see if he refers to the general order. Let's see. Just stop me. Just stop me when you see the general order. Wait, I'll go back to the beginning. Everybody just stop me when you see reference to the general order 2019-7. Just stop me when you see it. All right. Stop me when you see it. Stop me when you see it. Don't chat. Don't all chime in at once. Stop me when you see it. Stop me when you see it. Oh, wait. It's not fucking there. You fucking buffoon. Under my request should have been decided under the looser requirements of the court's general order 2019-07. Well, as luck would have it, as luck would have it, the court specifically referred to the pro bono program under 2019-07. So the court did that analysis already. He says, as I specifically requested referral to the court's local pro bono panel. I specifically requested it. Yeah, well, you requested under 1915 what was it? 1915 shit. Additionally, the order cites Palmer versus Valdez, which does not include. So Palmer versus Valdez does not include the inability to pay in its criteria. Well, what do you think? What do you think the odds are that he's abso-fucking-lutely wrong? What do you think the odds are? What do you think the odds are? William Palmer, yada yada, unconstitutional waiver of attorney, and number 2, denying Palmer's request for appointment of counsel pursuant to 28 U.S.C. 1915 E1. 28 U.S.C. 1915 E1. 28 U.S.C. 1915 proceedings in forma pauperis E1. The court may request an attorney to represent any person unable to afford counsel. That's fucking weird, isn't it? Because according to Wallace here, it does not include inability to pay in its criteria. That's really fucking weird. Really fucking weird. So Wallace was a California state prisoner. So the thing about proceeding in forma pauperis is that you have to you're at the mercy of the court. You apply for the informa pauperis and you give them your complaint, and the court makes an initial determination. Does your complaint have any fucking merit? Because we're not going to let you proceed in forma pauperis if you have a shit complaint. The district court's refusal to appoint counsel pursuant to USC 2815 1915 E1 is reviewed for abuse of discretion. So this is different than what the magistrate's refusal would be. Magistrate's refusal is clear error. District court would be abuse of discretion. Generally, no right to counsel. Exceptional circumstances, appointed counsel pursuant to 20 USC 1915. Yep. When determining whether exceptional circumstances exist, the court must consider likelihood of success on the merits, as well as the ability of the petitioner to articulate his claims in the light of complexity. Neither of these are dispositive, must be viewed together. Yeah. So 1915 is in forma pauperis, and which means that in order to get there, you have to have an inability to pay. When determining whether exceptional circumstances exist, the court must consider the likelihood of success on the merits as well as the ability of the petitioner to articulate his claims pro se in light of the complexity of the legal issues involved. Goddamn mosquitoes. Sorry, distracted. So that is a, yeah. But he doesn't make any argument there. He just goes on to say additionally. This isn't an argument. The court literally said that success on the merits and ability of the petitioner to articulate his claims in the order. In this case, paid the filing fee, made no showings, unable to afford counsel. That's the threshold question. Has also not been persuaded that exceptional circumstances exist, either with respect to his abilities to articulate his positions or his likelihood of success on the merits. So those are the things that that he needed to show and didn't. These mosquitoes are unfucking real. They're biting my palms. You'd think all the hair in my palms would protect me from all the masturbation I do, but it doesn't. Christ. Oh. Additionally, as per General Order 2019-07, the stay should have been decided based on a number of different factors than the ones the order used. General Order 2019-07 4-5:4. Well, all right. We are going to go to LACSN V. Legal Aid Center of Southern Nevada. There we go. And we want to do. I want to do pro bono. I thought I clicked on that. I did click search. Click search. PR. Fuck it. Pro bono. Boner. I had a link to this yesterday. I should have saved it. I generally speaking am aware that Chile is going to listen to what I say, misunderstand it completely, and then completely fuck it up in his pleadings. LACSN Pro Bono. God damn it. Federal Pro Bono Program. That's what I'm looking for. Ha cha cha cha. All right. Okay. The United States District Court for the District of Nevada adopts the following pro bono program for furnishing representation to pro se litigants in matters where the court exercises its discretion to provide such representation. So there has to be some authority given to the court to provide it discretion to exercise such representation. Oh, hi, Kenzie. The new dog is here, and Siobhan is desperately trying to get him to play with her. All right, so there are two situations where the court has discretion. 42 USC 2000E. This is EEOC stuff. We'll go ahead and look at it just so you can see. And let's go next. Exemptions next. Unlawful employment practices, and I think it's like 2000E-5. I think it's 2000E-5. Enforcement provisions. I think it's in here. Control F. Appointment of attorney. Yes. So in the EEOC section 2000E-5, subsection F, they can appoint an attorney. Don't throw up, bro. Don't throw up. That ain't cool. He's turning from a mostly kind of semi-country dog into a full country dog, and he's got a pack now, and he's been blossoming. It's delightful. So this is one way that you can get an appointment of an attorney, and the other way is 28 USC 1915. That sounds pretty fucking familiar. That might be the informal pauperis program. Fucking crazy, right? So there's two ways that the court can exercise its discretion to appoint someone. One way is under the informa pauperis statute. And so one of the necessary things that the court has to consider is the inability of the pro se party to retain counsel by the means. That means money. That means money. Potential merit, yada, 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 right? And then upon referral, so this is what the an assigned judge may refer it. Referral to the program is discretionary based on these factors, whether he can pay for an attorney. And then once he gets there, upon referral, it'll be sent to the pro bono liaison. And then the pro bono liaison will check to see if he can pay. They'll screen him. So yeah, I'm sorry, but you're retarded. So no, it's the same factors, like the court said. They use basically the same factors. It's basically the same factors, just split out a little bit more. A little more granular. None of these say inability to afford counsel, although inability to retain counsel is mentioned. Afford, retain, yeah. If you can't afford them, you can't retain them. Duh. I mean, you know, no one talks about lawyers being like the most giving or ethical or nice or wonderful or whatever. Everybody fucking knows, though, if you could pay for an attorney, you can have an attorney. That's the way it works. God damn. These goddamn mosquitoes. Oh. All the rain. So there are 5 common species of mosquitoes where I live, which implies there are multiple uncommon species of mosquitoes where I live. And after a rain, which I'm not judging this rain. I appreciate the rain, but not every mosquito lays eggs in water, in pools of water. There are mosquitoes out here. Most of the mosquitoes out here lay their eggs in either dirt, in areas where it will turn into a puddle, or in like tree hollows and things like that that'll collect water. It's fucking terrible, because I have mosquito fish in every fucking standing body of water that I can find. And like as soon as it rains, like mosquitoes are everywhere. The order ignored LVMPD's allegations in their motion. Plaintiff is unable to prepare his own pleadings. Again, you didn't actually cite that, and they didn't actually say that. This should be seen as allegations by LVMPD. The plaintiff will have problems articulating his claims and should be granted a pro bono attorney. But it's not up to LVMPD, and the court can't abdicate its responsibility to make these determinations and to just hand them over to LVMPD, especially if this court finds LVMPD's allegations true. If they find the allegation true that Chile was preparing your pleadings, well, they won't. The court won't make that finding. The court will just enter an order. My best guess is the court will just enter an order saying that Chile Decastro is prevented from practicing law in the District Court of Nevada and call it a day. The order also ignored that the stay was unimposed. Okay, but you weren't referred to the panel or denied an attorney after being referred to the panel. So I don't understand why that matters. Finally, the order mistakenly ruled the stay is moot. Wait, shouldn't these be in the same paragraph? Finally, the order mistakenly ruled the stay is moot after denying the motion for referral to the pro bono panel. It is moot. The stay also requested relief by way of a stay, even if the motion for pro bono services was denied. Stay for, I think that's the motion for stay for 1-2. Well, let's check that out. Motion for stay for page quattro 1-2. Stay the proceedings of this action until 4 weeks after I accept assignment of a pro bono attorney. That's not happening. or 4 weeks after I'm denied access to a pro bono attorney. Access to a pro bono attorney. You're being denied access to the pro bono panel. You're not being denied access to a pro bono attorney. Now, the court might be like, okay, fine, I'll give you a 4-week stay, but I don't know why the court would do that. Why would the court do that? So up here, he's saying 4 weeks until being assigned to pro bono attorney, or 4 weeks after denial by the panel. So this, I'm considering, is denied access to a pro bono attorney by the panel. You're not getting to the panel. Economy of time and effort for itself, counsel and litigants, right? But why do you need 4 weeks after you've been denied access to the pro bono panel? It's wonderful to see you too, sir. I don't know. He doesn't make a compelling argument. Here, the company being errors of law. Yeah, you're fucking retarded. All right, so next, plaintiff's unopposed motion to extend time to respond to the motion, or the alternative, for leave to file late opposition. Extension of time to respond to the motion to strike at ECF number 10. Well, let's take a look at ECF number 10. ECF number 10. That's a motion to preclude Decastro from practicing law. What the fuck? What the fuck? Fucking Christ. Ooh, he had blood in him. Nice. I guess she. Bloodsuckers are female. All right, so we're at ECF number 10. ECF number 10. Maybe it means 11? So there's a motion already. So responses were due by 8/7. Oh boy. 8/7 would have been down in this amended motion for Rule 11 sanctions. Oopsie fucking doodles. So it's due on the 7th, but on the 10th, he filed a motion to stay. Oopsie fucking doodles. Well, you done went and fucked up. You done went and fucked up. Now, will the court give him extra time? Yes. Because courts do that. Because why wouldn't they? Does the court have to? No. Will they? Yes. They'll give him all the rope that he needs to hang himself. Or in the alternative, for leave to file a late opposition in the interest of justice, motion made based, yada yada. Is there a memorandum of points? There's only 2 pages. Where's the fucking here's the whole fucking memorandum of points and authorities. No rationale as to why. Did not oppose, yada yada. Even though requested to say, even if it requested to say, even if my motion for pro bono was denied, we just went through that. It didn't. He wants till September 15th. The court will probably grant that to respond to the frivolous motion. so I may respond to it with help of counsel. I'm happy to regularly update the court as to the status of my search. The court doesn't give a shit about the status of your search. Additionally, I've been delayed by being illegally jailed 2 times in the last 30 days. Well, how about you quit being a fucking retard? How about that? Wouldn't that slow shit down just a tad bit? All right. More nonsense, more stupidity, more dumb fuckery. I'm going to start closing some tabs because my bar is getting full. All right. This is Chili's motion for demur to Bertini's Blue Bacon's answer. Now, I went over his answer. It was shit. Jesus fucking Christ. Are they going to bite my face? They're going to bite my goddamn face. Oh. Put on a little eau de deet. Eau de deet. All right. So a demur. What is a demur? A demur is like a 12b6 motion. It's failure to state a claim, things like that. Well, let's take us a little pinky poo, a little detour. We're going to do share this tab instead. We're going to go do code search. We're going to do code civil procedure, and we're going to go down here, write down objections to pleadings. Look here. Party against whom an answer has been filed may object by demur as provided in section 430.30 to the answer upon any one or more of the following grounds. Does not state facts sufficient to constitute a defense. The answer is uncertain or contract, and we're not contract. When any ground for objection to a complaint, cross-complaint, or answer appears on the face thereof, or from any matter which the court is required to take judicial notice, the objection on that ground may be taken by a demurrer to the pleading. When any ground for objection to a complaint or cross-complaint does not appear, it may be taken by answer. Any party objecting to the cross-complaint may demur and answer at the same time. Mm-hmm. 12b6 motion. It's a 12b6 motion. Sorry, I like reading. All right, so let's go to this tab. All right. Notice is hereby given that he's demurring, yada, yada. Plaintiff demurs to the answer on each of the grounds set forth below, yada, yada. Plaintiff's demur was technically due August 14th. When was this filed? August 18th. Uh-oh. However, plaintiff files demur late due to a failure to substantially meet and confer that was not the fault of plaintiff, qualifying for a 30-day extension under Code of Civil Procedure section 420 or 430.21A2. 430.21. .21. How about 430.41? Before filing a demur pursuant to this chapter, the demurred party shall meet and confer in person or by telephone with the party who filed the pleading that is subject to demur for the purpose of determining whether an agreement can be reached that would resolve the objections to be raised. If an amended complaint, whatever is filed, they shall meet and confer again with the party who filed the amended complaint before filing a demur to the amended pleading. As part of the meet and confer process, the demurred party shall identify all parts, yada, yada. There we go. The party shall meet and confer at least 5 days before the responsive pleading is due. So that means before. All right. So I've been through this before. 5 days before the response of pleading is due. The only response of pleading to an answer is a demur. So when is a demur due? A demur is due 10 days after the answer is filed. And shit, demur. Objections to pleadings. Is it denouncement? Where is it? Where is it? The only pleading in response to an answer is demur. 430.30. There you go. So you got 10 days after service of the answer to his pleading to demur to the answer. 10 days after service of the answer to his pleading to demur to the answer. I've actually been through that before, like trying to figure out like when it's technically due. Yeah. All right, where were we going on this? I don't remember. 430.41A2. 430.41A2. If they're not able to meet and confer at least 5 days prior to the date the response of pleading is due, the demurring party shall be granted an automatic 30-day extension of time within which to file a response of pleading. And how do you get that automatic extension of time? Well, you get it by filing and serving on or before the date the demurrer would be due a declaration saying under penalty of perjury a good faith attempt to meet and confer was made. So did he file one of those? I don't fucking know. I don't know if he did or didn't, because I get very few things posted about Decastro versus Peter in my Discord. But no one posted that he filed a declaration under penalty of perjury that a good faith meet and confer was made and that they could not meet and confer. So I don't know. I don't fucking know. So if it was technically due August 14th, then he should have filed a good faith declaration, or declaration that a good faith meet and confer was attempted and unable to be made. However, plaintiff files this demurrer late due to a failure to substantially meet and confer. That was not the fault of plaintiff, qualifying for a 30-day extension. And, well, maybe qualifying. Did you do the technical thing you needed to do? I don't know. I don't think so, but I don't know. Additionally, plaintiff requests court rule on the demurrer in its discretion in the interest of justice and because it does not prejudice any party. Yeah, having a demurrer granted against you really fucking prejudices a party. Having no good faith meet and confer also really prejudices a party, because he doesn't say in here that they've actually met and conferred. He said there's been a failure to meet and confer. That automatic 30-day extension is to give you an opportunity to meet and confer. It's not in lieu of meet and conferring. Plaintiff demurs under Code of Civil Procedure section 430.20A because the answer contains 430.20. Shit. You don't see this. There you go. There you go. Enjoy. Revel in it. Pause here if you need to. And we're going to 430.20. May object by demur to the answer upon any one or more of the following grounds. Does not say facts sufficient to constitute defense. The answer is uncertain. Or yada yada. So does not state facts or the answer is uncertain. Those are the two things that he can demur to. Does not state facts sufficient to constitute defense, or the answer is uncertain. Includes unintelligible or ambiguous. So he says it contains no new matter constituting an affirmative defense. Well, that's fucking weird. Because A says it does not state facts sufficient to constitute a defense. So I don't know what the fuck you're talking about there. You remember Well, she's been banned already from my Discord. I could probably ban her from here, but she hasn't been bothering me, so I don't really fucking care. So, no new matter constituting an affirmative defense. That's not what 430.20a does. Pleads inappropriate negative defenses. I don't know what the fuck that means. Not at least in California, and includes a prayer for affirmative relief. Does it? Does it? Does it? I have somewhere. I have. So we are going to be able to see if it does the things that Chili says it does. Titled Pleading Paper Blank. Good job, Katrinak. Pleading paper blank. All right. Reason for untimeliness. Defendant filed his answer on July 31, 2023. When did he serve it? Via electronic mail. So electronic mail, I think you get 2 days. Oop, you don't see that. I think you get 2 days under electronic mail. It's like what, 1014 or something? 1014 or something like that. I think you get 2 additional days. Notice is filing and service of papers. Notice and filing and service of papers. Two court days. All right. So 2 court days. So he filed on July 31st, 2023. So we're going to see, let me pull up July 31st, 2023. That was a Monday. 2 court days would be August 2nd. 10 days from that day would be August 12th. So I don't know where Chili's getting August 14th. Wait, let me see. August 12th, is that that was a Saturday. Okay, so yeah, it does roll forward to Monday. Got it. Okay, that's how I get the 14th. So he's right. It's the 14th. He had till the 14th. All right, so he emailed plaintiffs raising issues with the answer and asking if you'd amend it and if you could jump on the phone about it. The defense counsel emailed asking for authority. Cited those authorities. So Exhibit 1, we don't have defendant's counsel's email. Exhibit 1 and Exhibit 2. Let's see. Exhibit 1. What is all this fucking black redaction? Let's assume he asked for authority. Citing cases. Okay, well, that's not really what he was looking for, but all right, whatever. All right, he followed up August 4th, 7th, 8th, 12th, and 15th without response. Parties were unable to meet and confer due to no fault of plaintiff, supported by the attached declaration. I don't think I got an attached declaration. Nobody bothered to post in it. Oh, here we go. That's weird. LA allows you to do that? I know federal courts allow that, but I didn't know LA allowed you to do that. I didn't know LA allowed you to do that. So California rules of court require a wet signature. Okay, so he's an electronic filer. All right. Okay. That makes sense then. Courts in this district have exercised their discretion to rule on late demurs in the interest of justice, where there is no evidence that a late demur would adversely affect a party's rights. You cannot cite to superior court cases. You absolutely here's one problem. It has to be in the style established by the California Style Manual or the Blue Book Authority. Let's see. What was I looking for? I was looking for well, how about this? California shows you published citable cases. Citable opinions of the appellate courts are opinions published in the official reports and may be cited or relied upon by courts and parties. So it has to be fucking load. It has to be in the citable cases. And there is no Batikar versus CVS Pharmacy. There is no Batikar versus CVS Pharmacy. If you look at the case citation, see there's a difference between California's rules and federal rules. There are instances where you can cite district court cases. The rules of citation are a lot looser in federal court. California does not have that particular issue. You can only cite to California cases in California, to published California cases in California. You can't cite to superior court cases. You just can't do it. Additionally, ruling on demur and courts in this district, like courts in that district, follow the rules of the appellate courts and the Supreme Court. They may have local rules, but that's about it. Now, I do think that I think I found this one. I think I found this one somewhere. That's 2023. I found it somewhere earlier today. I couldn't pull it up because it is a LA County Superior Court case. and on Unicourt, I think. But it's meaningless for this. Additionally, ruling on the demur will allow a defendant an opportunity to amend their answer without requesting leave, which is in the interest of justice. That's like so backhanded and stupid. But okay. So it's late, and you're saying it's in the interest of justice because this will allow the defendants to amend it. It's fucking stupid. However, plaintiff files this demur late due to a failure to substantially meet and confer that was not the fault of plaintiff. Did you call? So hold on a second. Did you call? Declaration. I emailed. I followed up. What does that mean? Where's the phone call? Here's a pleading paper. There's a telephone number right there. Shit, this is going to get taken down. The law offices has a phone number that is published. It's a law office phone number for a company, not a person, a company. The company law office has a phone number at the top of his pleading. It is a company phone number, and Chili never said he called that phone number. And again, in order to qualify for the 30-day extension, he had to file a declaration before the time passed. And he didn't do that. Additionally, this clerk's reservation system was giving me errors from August 16th to August 18th. So after I was already late, the court's reservation system was giving me errors. When I first contacted the clerk on August 16th, the clerk said to contact my EFSP to resolve the issue. The EFSP said the clerk was incorrect and to contact the clerk and asked to be transferred to the e-filing clerk. I finally got a hold of the e-filing clerk on August 18th, and they opened up some slots. The general demur to the answer should be sustained because the answer contains no new matter constituting an affirmative defense. Yes, it doesn't plead any new facts. Objection by demur. A party against whom an answer has been filed may object to it by demur on the ground it fails to state facts sufficient to constitute a defense on the ground of objection when the ground of objection appears on the face of the answer or from any matter which the court is required to or may take judicial notice. Yes. Affirmative defenses must be pled with facts. Yes. None of them. Yes, that's true. Negative defenses. Defendant's first affirmative defense, answer number 2, is a failure to state a claim argument. In California, that argument is a general demur and not appropriate for an answer. Failure to state a claim is not appropriate for an answer? That's fucking weird. Failure to state a claim is not appropriate for an answer. The party against whom a complaint or cross-complaint has been filed may object by demur or answer to the pleadings in any one or more of the following grounds. The pleading does not state facts sufficient to constitute a cause of action. By demur or answer, the pleading does not state facts sufficient to constitute a cause of action. That looks like may object by demur or answer to failure to state a cause of action. And then there's another thing that if a party against whom a complaint or cross-complaint has been filed fails to object to the pleading, either by demur or answer, that party is deemed to have waived the objection unless it is an objection the court has no jurisdiction of the subject of the cause of action alleged in the pleading, or an objection that the pleading does not state facts sufficient to constitute a cause of action. So failure to state a claim is not something that they can waive. It's something that they can raise by answer. So what the fuck are you going on about? And why, again, are you citing to a superior court case? Affirmative relief. Defendant's 10th affirmative defense is a request for affirmative relief, which is not allowed in an answer. That is, well, you can't ask for affirmative relief. What are we looking at? 11. Whoop. As 11th, any alleged conduct by defendant was. What am I missing? What am I missing? Answer, paragraph 11. Answer, paragraph 11. Oh, paragraph 11. 10th affirmative defense. As a 10th separate and distinct affirmative defense, defendant is informed and believes, and thereon, and based thereon, alleges that his liability, defendant's liability, if any, is subject to offense of any amounts allegedly due to plaintiff. That's not an affirmative defense. He's saying that if Piratini owes you anything, then some of the money that Piratini owes you, joint and several liability, is going to be offset by some of the money that Peter owes you or somebody else owes you. It's not an affirmative defense. He's not saying that you owe him money, or it's not a claim for affirmative relief. He's not saying you owe him money. He's saying that some of the money that you allege is owed you by people other than Piratini. You dummy. All right, so let's see. Merbstradamus, what are we going to think on this? Is he going to get his hearing on the Mer? Well, that's a coin flip. That is a coin flip. The court might. I don't think the court should, but that's a coin flip. If the court grants the hearing on the demur, then most of the affirmative defenses go bye-bye. And it's simply because he didn't plead any facts. The negative defense is not waivable. That doesn't go away, and it doesn't have to come as a general demur. It can come in the way of an answer. And 11 is not affirmative relief. But I don't think the court's going to strike it or demur. I don't think so. If I had to pick, I mean, it's coin flip, but I don't think the court's going to do it. All right, so let's see what kind of dumb shittery we've got going on. Hello, Beck and Hall. You were first. You're amazing. Hello, little of this and that. Hello, Neil McDonald. Hello, Paul Berry. You get what you pay for. Generally speaking, yes. We get what we pay for with you, Murby. You do. You absolutely do. Demur. Big eyes. Demure. I like that. Demure. Kate is also live. Well, I'm sorry to hear that. Well, I mean, awesome. You should go watch her. She's a lovely lady with big ideas. Rhymes with manure. Wait, isn't she doing something on that Cyrax guy? Like, hasn't she beat him up enough already? Clearly an error. Howdy, Ryan. Hey there, Madison. How many motions for consideration, reconsideration can you file? All of them. Chili is everything but demure. Two different words. Merb has law, Kate has cow, your choice. Indeed. What kind of operation is this? Probably a pretty dumb one. If a person initiates an action pro se, would it ever be reasonable to stay the proceeding to get an attorney for themselves? Why would the plaintiff just dismiss so the attorney could refile? Well, there might be lots of reasons why a plaintiff would dismiss or would not dismiss to refile. And it could be things like the statute of limitations might have run in the meantime, things like that. So it would be more appropriate for the court to stay or to continue things out to give someone time to get a hearing. So in in California, we have case management conferences, and case management conferences are pretty aggressive in some counties, where they really want to know what's going on, and they look to make sure that there's been that the complaint has been served and an answer has been filed. And then once those are kind of on track, then the court is pretty aggressive at pressing towards getting the case to trial. And the reason for that is there's statutory obligations on the courts to have X number of cases resolved in Y time. And there's also the whole issue with if a case isn't resolved within 5 years, it's going to get dismissed. So there's time constraints, and the courts move on those. And so a lot in those case management conferences, a lot of what you hear from the pro se plaintiffs is that, yeah, I need this case management conference continue another 60 days or 90 days so that I have time to get an attorney. That's pretty common, and the court is pretty likely to grant that. You do make promises. You promise us a pantsless night. Why pantsless? Like, I don't know why you're not. It makes me feel a little weird saying this when you have a picture of a kid. I don't like that. I don't like that. I don't want to talk about being pantsless to kids. The law firm of Decastro, the pro se litigants of Decastro. Every night is a pantsless night. Absolutely. Hello. Sounds like a promise kept. Just got here. This is a Decastro pleading that his clearly are about as clear as a lump of rock. Okay. Of course. B for you. Okay. I'm going to row my boat around my moat with a torch tonight. Okay. I love black BBWS. Well, good for you. I put alligators in the moat. Be careful. Music biz Marty is the king. Okay. Good for you, dude. There are no alligators in Wales. There might be some like in zoos or something. Mightn't there be? I know Wales is pretty small, but there might be some. There might be private collectors. I don't know. Oh no, he has to have specific objections. What are the odds of that happening? Somewhere around 0. There are now. A1A Beachfront Avenue. Ice, ice, baby. Cyrax is mad at you. I don't give a shit. LMAO! You meant to go to Kate's stream, dude. How come Murby always talks about legal stuff? Why not show how the Kings are going to do in the Devonba? I don't give 2 shits about sports ball. Lol. DEET is awesome. It is awesome. Lol. Hey, you can use that DEET to fix your cloudy headlights. DEET will make your penis fall off. Well, now you tell me. Something I could have known before I rubbed it all over me. DEET tastes great and less filling. DEET is the bomb. It melts plastic. Like the plastic bottle it's in. I don't think this is a plastic bottle. It looks metal to me. I could be wrong. It's good to see you've come into your own. Well, thank you, Denise. I'd come into your own too. Kate's stream is just a bunch of terrible people going at it and acting better than each other. You figured that out, did you? Except when I'm there. Then it's terrible people going at it, acting like they're better than an incredibly worse person. Hand pink waving. Hand pink waving. Chili is really looking ragged these days. Well, I mean, you know, Sue ZQ, would you like people judging you based on your aging? Pro boner. I watch Murr because he shares my middle school sense of humor. 13-year-old sense of humor for life. Kate likes trolls and cows. It's her right. It is. And she has lovely udders. Flamethrowers are effective against mosquitoes, allegedly. I will take your word for it. Ithiar, Ryan. The Decastro law firm is pleased to announce its newest attorney, Floyd Wallace. Mr. Wallace brings with him 3 weeks of frivolous lawsuit experience, also a graduate of the Decastro School of Law. Hello, Merb and all. We are enjoying a lovely rain and some Merb time. Well, I'm glad you're enjoying some lovely rain. We had some rain today, but it's ever so slightly cloudy. we're not really like tornado or hurricane weather out here in California. We're pretty nice, and it's a dry heat. Music Biz Marty's the king. You've said that. Okay. Clearly cloudy. Constitutional law scholar. Free is good. Trifold. Good morning from the UK. Good morning to you. If I ever went to the UK, I would try to hit up all of the pond YouTubers and try to schmooze into seeing all their ponds. Because my God, the UK is they take their ponds seriously. I have some really serious pond envy. My pond is not nearly as cool as a lot of these guys have. Floyd sex tours. Wallace can't afford a lawyer. Well, I mean, that's kind of judgy. Like, he was shopping for a wife, not for sex, allegedly. And even if he was shopping for sex, like, what if you prioritize the sex over a lawyer? Like, wouldn't you? I would. I need a new penis pump. I wore my old one out. It's not my bag, baby. Oh, what you drinking, Merb? This is Diet Pepsi and bourbon. This is just your daily Merb stream reminder that all politicians are terrible and Chile wants to be governor. Please continue. Excellent point, sir. Anybody who wants to be a politician is probably a bad person because all politicians are bad people. But in Chile's defense, he's not been allowed to become a politician. There have been people who've done way worse things than Chile has who have gone on to become politicians. So if the powers that be are preventing Chile from becoming a politician, maybe he's good after all. Logic. If you tear a trifold in half, is it still shite? No, it is half a shit. Lol. A third pile of shit. If you tear a trifold in half, it's still a half. It's not a third, sir and or madam. Obviously, I knew Merb would be live tonight, so I've not gone to bed. Cuppa and a pants of spurb. Good time. It's a very short good time, but a good time nonetheless. The best 30 seconds of your life. Steve Miller talks. Got to save some cash for the other professionals he hires, allegedly, in my opinion. Tearing it vertically or horizontal. Indestructible trifolds cannot be ripped in half. Laughing. Clearly, you and Decastro went to different law schools. We sure did. Wait, I went to one. He didn't. So not different. Damn, you got us there, Bill. Plus, it's now on the internet, so it must be true. It must be. It's clearly Merb Live. Clearly. Merb, your head will hurt less if you stop trying to make sense of this case. LMAO. Lol, God calling down to Merb telling Zeus, Lol's watching me get this guy hooked on covering this nonsense. Yeah. But thank you for doing so. The Peanut Gallery appreciates it. Well, I enjoy it too. That's why I do it. But it's great that you guys can enjoy it with me. Ouch, I just lit my nipples on fire. We covered that. I will kiss your boo-boos and make them better. Merb would rather be a fish. No, that was Limpet something. A Don Knotts movie. I don't remember. The Incredible Mr. Limpet. Really freaky movie. Like, at the end of the day, it was a really freaky movie. I'm starting to sense some jealousy because you don't have your own indestructible trifold available for sale at the low price of $19.99. Act now and receive a free rubber band with purchase. I'll give you a rubber. I think the free rubber band offer turned out not to be economically viable and was withdrawn. I'd rather be fishing too. Something hot. Fishing is enjoyable. I loved going fishing with my dad. Now, I don't like hurting fish, so I don't really like to fish, but I like to fish with my dad. It was the experience, being out there. That is very sad news, but understandable. Everything on the internet is true. I used the free rubber band as a cock ring, but I had to wrap it around 4 times. Well, don't hurt yourself. Hey, Peanut, happy Monday. Even with the free rubber band included, the holidays are quickly approaching, and I can think of no better stocking stuffer. I'm only here by special appearance. To know why Floyd is talking about the lead singer of U2, I bet he prefers some good, trashy, police-hitting gangster rap. Needless to say, Floyd would have trouble spelling you two anyway. Maybe Floyd can afford the law offices of Stout, and Stout pro se litigants. I hear they're highly recommended. They have smaller rubber bands. Nice. Oh, is skosh a legal term too? Making a legal dictionary. You and blacks. Blacks also made a legal dictionary. But clearly anyone who disagrees has not reviewed the record. Clearly. I like that a 20-year law scholar has to keep coming back to say, oh, but I'm pro se. Got to give me a third and fourth chance. I know. You'd think if he was that fucking good, he'd win on the first shot and not have to go reconsideration after reconsideration after reconsideration. And he also wouldn't have to beg for the special pro se tolerances. Like, I didn't plead this, but I'm pro se, so you should just assume I should have pled it. Verb, I no longer believe you have a lot of degree when you obviously do not recognize the defense. Well, you figured me out. 25-year. Nice. I got your back, cousin. Well, hello. Do you need a pet? Sorry. I have to pet Siobhan. She has nudged me appropriately. Happy birthday, Madison Lee. I don't know why we're saying happy birthday. I mean, no one's, they're all lying to you on the internet. Oh, hello. I'm sorry. Where are we at with the Kate and Abrams versus Chili? I hate Abrams as much as Chili. He's a dog, but while not hating on Kate, I don't care for her much. Can we just dismiss all with prejudice? The Decastro versus Abrams et al. Has been dismissed, not with prejudice, but without. So I'm glad you're here and enjoying yourself. Grab a beverage. Not to be confused with the did to defense. That's a rough one. Along with the I'm rubber, you're glue. Between the three, Josh wins the prize for the biggest POS. Okay. Now Madison Lee isn't real. Probably not. May the trifold gods bless you. Will his dumbass appeal in the federal case have any chance of delaying his crim bench trial on 9/12? No. He doesn't have in the LVMPD case. No, he does not have grounds for an appeal. I would not be surprised if they deny his appeal without opinion. If they just say denied, give a slip opinion, just appeal denied. They may give an opinion, but he's dumb and wrong, and the case is the precedent is clearly against him. I don't know what the fuck he's thinking. As crazy as it seems that he would run for governor, him and Newsom would be a toss-up to me. Could you do worse? I mean, pick any politician. Could you do worse than that politician? Probably not. There are towns that have like dogs or cats as their mayor, and they're like, oh, well, he's better than any human we've ever had. And you're like, well, yeah, okay. It's bad that animals are better politicians than humans. All right. Think of all that Chili could accomplish if he used his powers for good instead of evil. No, he's shit. He's just shit. Murby. I smell bull poop. Reaners, right? Something like that. Dumb and wrong sounds like a good legal argument to me. Well, that's Chili. I filed entry for default today. Well, congratulations. I hope it works out for you. Are the pro boners in the room with us right now? Well, if you can't feel it in your butthole, probably not. Hashtag CNL, hashtag PLF. I don't know what that means, but I'm sure it's insightful. Why can't I find a site to Teschlands versus Danforth? The one case that makes every police officer tremble in fear. You just haven't looked close enough. It's in the fine print. Look at the footnotes. Floyd Wallace pays me, quote, reasonable attorney's fees. Well, is that true? Floyd helped me a couple of times. Well, I'm glad to hear that, Mr. Reaners. Kate P. lies like a doormat. She does not always, but when she feels it's to her advantage, she is more than willing to distance herself from the truth. I read him of the drama. Well, congratulations. 34th Street. Hand pink waving. What's up, Coda, my man? When are you back? I miss you, bro. Been rewatching your old shit. You need to give me some fresh drama. I enjoy listening to your shit. I know it's terrible. You have a terrible podcast, sir, but it's so fucking addictive. Oh, Terrible. Terribly good. Terribly good. I don't know why. It's just addictive. I tried to explain to Chili once what actual damages are like loss of revenue or medical bills, but it whooshed right over his head and he kept returning to his emotional damages. Yeah, emotional damages are real. You have to fucking prove them, i.e., go to a fucking shrink, provide your medical bills for your counseling. The one of the law firms that I work for has this shrink. He's a psychologist, which is the worst of the two. Psychiatrists or at least doctors. And this firm sends everybody down to Oakland to see this one psychologist, and he will write whatever the fuck this attorney wants him to write. It's terrible, but yeah. Where is Shiz, aka Dump Truck, probably faking being pregnant again? She was pregnant. She had a miscarriage. I think the kid was like 4 months along. I mean, your homeboy Turtle Boy covered it, so like just trust Turtle Boy's reporting a little bit there. And she's mad at me because I'm free speech and she wants to censor coded. Clearly, Chili has more to learn. Maybe when he's a 30-year scholar, 30-year lol scholar. Yeah, probably. The goddess of truth. Hugh. I don't know how to pronounce Hugh. H-I-W, Hugh. Hugh, much longer do you think this portion of the complaint/suit proceedings will go on before the court will make a decision to hear it or dismiss the case? I don't know what the fuck you're talking about. So the general way that lawsuits progress is you file the complaint, you serve the complaint and summons. The other side answers it. Discovery ensues. Each side gets the opportunity to figure out what the other side has. And then the parties will set it for trial. There are short circuits to that general process, motions to dismiss for like a 12b6 style demur motion to dismiss for whatever, for a failure in the pleading, or a motion on the pleadings, like even if everything alleged in the pleading is true and all the uncontested facts are true, I win, or a motion for summary judgment that if everything that we've discovered at discovery is true, like if all the responses to discovery are true, I win. Those are shortcuts, short circuits to that normal approach or settlement. But the courts don't just make a decision to hear it or dismiss the case. Unless you file a motion to dismiss the case, the court isn't going to sua sponte do it on its own volition. The court's not going to do it on its own volition. Jason Dollarhide is alleging that Floyd sexually assaulted his wife. Well, like when did we start believing what Jason Dollarhide said? Like I saw that on my Discord. Jason Dollarhide, everybody on my Discord is like, oh, he's a fucking liar, blah, blah, this, blah, blah, that. But then as soon as he makes an allegation against Floyd, then all of a sudden we believe him. Either you believe him or you don't believe him. Either you believe him for everything or you believe him for nothing, unless you have some specific facts, but you're just taking this at his word. So how about no? How about I'm going to believe that Floyd is innocent until proven guilty, because I've never heard of Floyd sexually assaulting anybody. And like, did she call the police? Thanks, Welsh News Now. I keep getting Cholita confused with that ShamWow guy. That ShamWow guy is way cooler. Who cares where Shiz is? This isn't about her. Well, apparently somebody cares because they asked. He, coded friend 001, hand pink waving. Surrender Monkey want to know if you're still planning a holiday stream. Well, that would be great. I think coded you should do a holiday stream. Hand pink waving. Hand pink waving. Hey there, Matt Decastro's real. Real is good. Hey, coded, I meant. You should invite Chili on for the next stream to go over his filing together. Offer to split the monetization with him. Well, I don't monetize my channel. I never have. I never will. So he probably won't go for that. Howdy, Merb and everyone. Well, hello, guess who? Coded friend says, hello, Laura. If you spend all your money on Colombian powder import, can you get a pro bono attorney? If you share the marching powder, sure. Oh, yay, it's coded. Stop. Coded. Hope your family is having fabulous holidays. But know your streams are missed. They are missed. They are missed. Somebody stop me. Floyd's signature looks like he's barely literate. My signature is like that. Just bloop. That's it. That's my whole signature for my whole name. Bloop. If you sign your name enough, it gets shorter and shorter. Nah. Coked said I should die. Cosid? I don't know who that is. Stop. In the name of love. Laura, we are enjoying. The streams will have to wait a few more days. Well, I'm glad you're having fun. My favorite part of Merv's live streams is learning legal jargon such as peeky poo. Take that shit to the bank. Specifically. Nah, Coded said I should die. I mean, he's not wrong. That's great, Coded. Always pro boner. Non 0% chance he's wrong. 100%. 69 to 1. 100%. Really, Madison Lee? I don't even know who you are, nor do I care. That's the appropriate answer, Coded. Even better. Well, so we switch from he said I should die to he doesn't know who you are. Yeah, you're a terrible person. I'm going to Tesco to hang out in the bread section with Mark. Well, that sounds fun. Tinned meat section is better. Don't get me wrong, the white t-shirt is a good look, but do miss you dressing up with your finest Hawaiian shirts to do these streams. I never did these streams in my Hawaiian shirts. Those are for the car. Those are for when I'm going to work. I wear Hawaiian shirts at work most often. Usually, sometimes it's kind of awkward. Good to know. Please vote for me for Home Secretary. I don't think I'm eligible to vote in Great Britain. The mosquito is the most dangerous animal on earth. It spreads a lot of bad shit. Coded, kind of sad. You could spend an hour telling a woman her life doesn't matter because of your religious beliefs, and you don't even remember. You don't matter to him. You don't matter to him. And you don't matter to me. And I don't know why I haven't banned you from here. Merb can't wear Hawaiian shirts anymore because he was ousted from the Boogaloo Boys. I've never been a Boogaloo Boy, nor do I associate with any of those. Merb! Ha ha ha! How could he be ousted? He's a president of the club. I don't think so. Merb needs to shave that beard. I don't think so. He is one seriously busy guy. Okay? Malaria Merb. Malaria Merb. Coup d'etat. Kind of coup d'etat. Bloody insurrection. Mutiny. They made Merb walk the plank. Don't believe everything you read on the internets, Laura. He is one busy guy getting arrested in Oklahoma while filing motions in Vegas. All Chili does is fuck shit up. Show the new dog. Merby's around somewhere. He was in a video I did where I was walking him, or where I was walking, and he was walking also when I was visiting my sister. Had my baby and named him Cyrax. You guys are fucking mean. He was outed by the Boogaloo Boys. Was he? It hurts my head to read along this crap. Floyd would need a calculator to add 2 + 2. No one believes Jose and his crew didn't write these. Jose wrote them. Decastro did. Al said, not sure now, because Jose Roberts told me not to believe the internets. Okay. I've been screenshotting your duck hunting. You're a fake vegetarian. Laughing. The president is not required to wear the Hawaiian shirt uniform. Retarded legal term. Absolutely. Hello, Kenzie. Kenzie's his new dog. He's a brick. Yay! And the twin? Ooh, Jose, gotcha. I thought most of those involuntary cell types were probably closeted. Rewinding. Shruggy is the other twin. Clearly. Don't know why, but I do wonder what drugs Chili's on when he writes these. I don't fucking know. Like, I don't know. Like, he might just have ADD, like really severe ADD. ADHD. Stop stalking me, Madison. I heard that Wallace is a national treasure. I assume that's because of how he shows his patriotism by getting arrested in every city he visits. Illegal arrest. That for sure. Maybe. What if you can afford an attorney, but no attorney will take the case? Show me that fucking happening, and then we'll talk about it. Show me that happening, and then we'll talk about it. Like, the worst people ever have gotten attorneys. The worst people ever have gotten attorneys. Every single time. We don't care. The whole point of attorneys is to represent people, whether you like them or not, whether you believe in what they do or not, whether you approve of what they did or not. You are entitled to an attorney, and some attorney somewhere will take the case. I'm so rich I could buy a whole fleet of lawyers, but you can't even buy a working toothbrush. Never. With the Floyd arrest fundraiser happening, where will Chili's next vacation be happening? Why not just do Columbia again? That's where all the good powder is. Shruggy. Merb, if you make me mod, I will block everyone so you don't have to read all the comments at the end. It would save you a lot of time. It would. It sure would. But I could always stop. I'm not addicted. I could always stop. Looking for a legal opinion. If FDR came back as a zombie, could he walk? Ooh, fuck. That's a good question. I'm going to go with no. I think he'd be doing one of the crawling zombies. But I could be wrong because I'm not a medical doctor. Oh, good idea. Merb doesn't read comments when he's getting eaten up by mosquitoes anyway. They're fucking, like, I have sprayed so much DEET and they do not fucking care. I'm here to help. I never get a notification. Yep, good to see it. Mosquitoes suck. And if they love you, they swallow. If Floyd needs an attorney, wasn't it his responsibility to get one before filing this stupidity? Not necessarily. You could be running up against statute of limitations concerns. There are mosquitoes there. Thank you, Jose. Merb, how's the pup? He's not a pup. He's like 12 years old, and he's doing good. He's packing up. He's playing with the other dogs. He's doing really well. Drinking alcohol attracts mosquitoes. Well, that fucking explains a lot of shit. ICB, bro. You need some of those citronella torches. Probably doesn't actually do anything, but fire is fun. And indeed, and they don't do anything. We have these little electronic things with like patches you put in them that are supposed to put up scents. We've got bug zappers. I mean, like, the list goes on and on. The only thing that really works is DEET. Hey, mosquitoes exist everywhere except Iceland and Antarctica. Well, sign me up to move to Iceland. Ooh, I love Iceland. Well, sign me up not to move to Iceland. Humans attract mosquitoes. So does your mom. Iceland is beautiful. Oh, it is. Some more than others. And Iceland supports single mothers. Oh, I fucking hate you with a passion, Madison. Yes. Stop breaking the law, asshole. I'll try. 11 pages. Jesus fucking Christ. That's 3 arrests as of Thursday, August 17th. Well, but who's counting? The dumb fuckery is strong with this one. Absolutely. Floyd is a Chill logic. You demur me, I double demur you. Did someone demur Chili? I don't remember that. Laughing. Murby better get one of those afterbite pens if you puff up from the mosquito bites. I don't. I'm actually getting quite a bit like when I first moved out here, I was so soft and tender, and I'd get all bit up and it was bad. But now the itching doesn't last long. I'm building up a tolerance. The smell of bug spray aftershave on a man is so sexy. Moisture alert. Double dog demur. Which is worse, bullshittery or fucktardery? Yes. It is, Laura. Jesus, fucking hate you. I triple dog dare you. Icehound, we tauded. Is anything ever his fault? No. We will. Technicalities of law are so lame, but they're the best. Shouldn't the courts already know that Chili's never wrong, and no matter what, it's never his fault? Duh, absolutely. I trifle dare demur you. No take back and no erases. Right, because he clearly always tries to meet and confer in good faith in a timely manner. Well, at least he did a good faith declaration this time. At least he did that. So he's getting there. All right, stop. Collaborate and listen. Ice is back with a brand new mission. I thought it was brand new mission. Was it brand new invention? Silly Merb. Rules were meant to be bent and deadlines stretched to fit the needs of the great Chili Decastro. Flow like Harpoon daily and nightly. Will it ever stop? No.
I don't know. Turn off lights and I'll glow. Why would it be? He's a constitutional laws scholar. Could the man for Blue Bacon's foam number? I need my sail foam. Have anything to do with YouTube pulling down video if a number is shown? I don't fucking know. To the extreme, yeah, okay. Double secret demur. Merb, you agree to represent Floyd. We can split the lawsuit proceeds 3 ways after Elite Laws takes his 50% fee. No, because you know, if Floyd approached me and if Floyd had what I thought was a good cause of action, absolutely I'd take it. Like 30 to 50% of 40 grand. Fuck yeah, dude. Sign me the fuck up. I will do that shit. I will do all the things it takes to get associated into Vegas, yada yada. But it's not. He doesn't have a winning case. So why would I do that? Yes. Is there any way Chili can just go away? He's a cancer on the genitalia of social media and society. Chili is a member of society. And it's not just the people we like that are allowed in society. It's also the people we don't like, unfortunately. Should you keep going? You should keep going all the way until you fucked completely off. That'd be great. That'd be great. Merb, you're boring Madison Lee. Could you please make this legal nonsense more entertaining for your audience? At least stand up and let's see that pantsless wonder. You gotta buy me dinner first, Laura. We've been over this. No free peeky poos. No free peeky poos. That might work. May not, but may. Order in the chat. Do all jails offer electronic filing for their guests? That is a function of the federal district court, not the jail. The jail may or may not allow access to electronic devices such as computers and or cell phones. Maybe if Floyd had invoked the symbol of the Illuminati, he might have been referred to the pro bono panel. Maybe. That's a good point. Maybe. I do love it when Merb disses other attorneys. Well, some attorneys suck shit. I was just trying to summon WTT. Leave or Chili, who I am definitely not, and Merb will sue you, Dunscap. I will not sue. I don't want anything to do with birds. No worries, and I did try to help, even though you weren't bothering me at all. I'm taking down names for future litigation. Oh, okay. Yay, I want a lawsuit. Hey, everyone. Hurry up, Merb. My butler's waiting to give me my sponge bath. Merb, your chat is full of agents of Peter. Well, I've got a big Peter. I'm lying. I don't have a big Peter. It's fine. I know Merb thinks I'm stupid. No, I think you're a piece of shit. There's a difference there. Hey there, Madison, lol, Logan. That's what Blue Bacon said until Chili sued him. Laura, I'm late for the party. Logan, I know, Matt, but I want this. I was shaving Miss Sack. Nice. You're no longer Harry. Sadly, the mosquitoes were on time. We know, Harry. We know. So that was you peeking in the window, perv. Overturned Decastro. Hi, Droid fan. Hi, Droid. Joey's biggest problem is that he thinks he can bullshit everyone like. I love it. 77 was the year Star Wars debuted. He bullshits his followers. Yes, he thinks that judges are stupid. And generally speaking, you're not stupid if you become an attorney. Your mileage may vary. And even more generally speaking, you are even less stupid if you become a judge. He said they emailed him back, he said they emailed him back, though, didn't he? Yes, he said that, but he didn't provide it. So I think Decastro gets plenty of turned over. Those old guys aren't friends. They're more like his employer. They're more like his customers. He services them, I believe, in my opinion, allegedly. He sucks their dick for money. Sugar daddies. Maybe he shouldn't record the call, and so he didn't even try to call. Maybe he couldn't record the call. Maybe, but he has never really minded the single party consent before, so why now? A dingo ate my trifold. Did we move from Wales down to Australia? Australia, mate. Well, this would have been over long ago had they just nipped it in the bud. Just nip it. Nip it good. Hey, I like it. Barney Fife. Why is Merv refusing to accept that nothing is ever Chili's fault? Was that not covered in first-year law school? Well, I'm only a first-year family law attorney, so maybe I just haven't figured it out yet. He drives a van because of mobility with his job. Nice. How have you only got 6K subs yet, you? That's a good question, and I, for one, am glad you asked. Have the same viewers as one of Jose's lives? Again, another good question, and I'm glad you asked. Everyone like on Merb video is $1 in the G-string. Oh, please donate to my G-string account. Merb is a family attorney. He knows nothing of federal law. Decastro is a law scholar. That might be the reason. That is probably the reason. Whose G-string? My G-string. Ooh, nice. You should be wearing a G-string. Nice. Chili has hundreds of thousands of supporters. When he is live, there are at least 50,000 in the room. Probably. No dingoes and whales. Merb's viewers get rewarded with the chance of having Pantsless Burp stand up just once on a live. Does Chili do that? I think not. Tell Merb to unban me on Discord. No, you're not welcome there. Chili was telling his viewers that the two would be a constitutional law, that they too would be a constitutional law scholar if they watch his videos. Well, he lies. Now you figured it out. Ta-da! When Chili was live streaming, he let a little Chilito make an appearance when he dropped the laptop while he was driving. He since deleted the video when no one was impressed. I'd like to see it. I've been clogged with Nutella ever since Denver. Well, that's too bad. I plan to be impressed if Merv ever drops his laptop in his lap. Prepare also to be disappointed, just like every other female ever in my life. It's so good to see you came into your own. Thank you. And again, I still will come into yours. Little Chilito, is that a cock-a-doodle-doo? Maybe. Big eyes. A cock-a-doodle-too. TLA. All bloodsuckers are female. Confirmation that Merb is a misogynist. And I don't want to hear any argument that your statement was clearly factual. You admitted self-abuser. Well, I don't retract my statement at all. All bloodsuckers are female. Done. QED. Mine is in plastic. So's your mom. What's in the bottle? What bottle? And when I say self-abuse, I mean both re your hairy palms and spraying your junk with industrial strength DEET. The tingle is worth it. So don't fucking judge me, all right? We're not here to kink shame. We're not here to kink shame. You're welcome, Devin. You are correct, sir. Yes, I am fucking correct. No, lack of money is preventing Chili from going to an office, not the powers. Sure. Chili thinking, that's where you made your mistake. I make lots of mistakes, so don't hem me in on this. A Chili once grew on a vine, its color so bright and divine. But when it was picked and then quickly licked, its heat was nowhere to find. Well, that's sad. What about amateur boners? Sign me up. How much longer can the motions process go on before the court either dismisses the case or forces it to be heard? Is there any legally time frame set forth in law? No. CNL, Chili never learns. PLF, poor little fella. Goddess Truth. Hey, sweetie. Hello, Carl's Order of the Squirrels. The Constitution is overrated. Heller is perhaps the worst SCOTUS decision in history, and we should ban guns. Freedom. I hate you so much. Even if you're joking, I hate you so much. Where do you keep your trifold? You'd have to buy me dinner to find out. LVMPD. Fucking hate you. With what you answered, what procedurally determines ending the period of motions and discoveries to either dismiss a case or to try it? Those procedures cannot continue ad nauseum, can they? Generally speaking, the court will have management conferences, case management conferences, where they're like, hey, where are we at? I'm going to go ahead and set, you guys haven't like voluntarily set yourself for trial. I'm going to go ahead and set you for trial. The court gives lots of leeway though. Most cases, I would say on average, a case take about 2 years. On average, most cases take about 2 years, unless they settle. If it goes all the way, you're looking about 2 years. I have non-family law. Like I have a civil case that was set for trial. It's been up for trial twice. They didn't have a courtroom or a judge for me twice. And it's currently set for, if I remember correctly, January of 2024. And that case was filed in 2019. So we're running out of the end of that little son of a bitch. It takes a while. I mean, it's not unusual. The mosquito has 47 teeth. So does your mom. Decastro, his trifold scam is a bust. He's looking for new territory. His e-begging is getting old, and his jock sock never made it off the ground. Suggestions? Yeah, go back to sucking dick for money. Merb, I don't watch all these live streams, but I appreciate you sharing your hard-earned knowledge with us free of charge. Who said it's free of charge? Wherefore, legalese blows. There you go. Just wondering, has Merb ever discussed the legality of these child predator sting channels? I feel like they have replaced First Amendment audits and fringe public. I don't. But like, I don't think that they're illegal by any stretch of the imagination. I wouldn't like confront people with it. I would just call the police. Like, I don't know. Like, I don't know. Merb's recent defense of free speech in that last stream was epic. Truly enjoy it. Well, I'm glad you did, Turtle Boy. How are those dogs doing? They need to make an appearance. Well, it's dark out here. We don't have street lights, so you wouldn't be able to see their asses. I know everybody loved watching my dog's asses when I walked them. I see Turtle is still immature as fuck. Well, what did he say? What in this was immature, Jose? What in this was immature? What was immature? Like I get it. People react to Turtle Boy. They're very polarized. It's I like Kate, or I like Turtle Boy, or I like whoever. But here's the thing. All these Massachusetts people are like fucked. And what he said was not immature. Merb, in your opinion, what's the biggest, most impactful Supreme Court ruling? Marbury versus Madison. That's all, folks. I love you so much, even if you aren't joking about having a tiny pee-pee. Well, thank you, I guess. Merb. I've been told softener sheets repel mosquitoes. Well, you've been lied to. Thanks for watching. Have a great day.